Yes, Your Honor, I'd ask for 5 minutes, please.
Okay, very well. You can proceed.
Thank you very much. May it please the court. Your Honors, I'm Melissa Giassi with Giassi Law. I'm here on behalf of Mrs. Amina On, who is the appellant in this case and was the respondent in a stalking injunction proceeding in the lower case. We have articulated in the brief what I think are very basic, fair, and what I would submit are fundamental rights that mandate the reversal of the second stalking injunction entered by the trial court in this case. There was a prior injunction entered in 2009, and we do in the brief provide the court with some of the factual basis leading up to that, but we make it very clear that, obviously that's not the subject of this appeal, and my client is certainly not seeking to challenge a judgment that was final at some point in 2019. My client very strongly desires her day in court, where after she has the opportunity to review a petition or a motion, the allegations therein that might warrant the extension of the first injunction.
Ms. Giassi,
Yes, Your Honor.
why shouldn't we view the trial court's action, which was discussed during the hearing, there's several references on the transcript to the possibility of extending it. Why shouldn't we view that as a modification that's within the trial court's inherent authority to do?
Well, first, Your Honor, that was not relief that was requested in the motion. We go directly to the motion to contempt.
Well, I understand your argument on that point, but your client was present at this hearing. The
Yes,
issue about extending the injunction was discussed.
Well, I think and
my question goes to this. I don't think there's any real debate about this. Trial courts have broad discretion to modify an injunction to achieve the purpose of the injunction. And it's pretty clear to me from reading the transcript that that's what this trial judge was trying to do. I'm asking you why we shouldn't view it as a modification versus the granting of new relief that would have to be pled, or at least under your argument would have to be pled.
Sure. Respectfully, I do think that if there was a request to modify the injunction, that it would have to be brought in writing. And I think that goes parlays
So
into
that's your response, is there was no pled request, therefore
Well, that's
the process on the modification.
Well, that's my first answer, Your Honor, but I want to, direct the court, and I think we tried to correct some of the factual allegations in the answer brief, and when you set the tone for the motion was brought based on contempt allegations. At the very beginning of the hearing, trial counsel for appellee says, we're just here to enforce, if the court is so inclined we need to file a subsequent motion to extend the injunction. And then even during testimony, the appellee was asked whether she intended to eventually file a request to get an extension of the 2-year injunction. She testified, of course. When you look at the totality of what was argued by trial counsel for the appellee during the hearing, when you look at the comments from the judge, I respectfully submit, Your Honor, that I do not think that what the trial court was trying to accomplish was a modification of the original injunction. She was there looking at whether my client was in contempt. And
well, she says at the end of the hearing, or somewhere close to there, that she's going to reserve on whether to extend. And at that moment, your client's trial counsel says, I would object to 5 years. He doesn't say anything about he would object to an extension. He just objects to the term of years.
And he goes on to ask for an evidentiary hearing if the court's going to consider. And I think that transcripts can be read in more than one way, but he seems to be saying if the court is going to extend the injunction, I'm asking for an evidentiary hearing.
But there had just been an evidentiary hearing. And even to this day, I don't think that you've actually identified what it was that your client would have presented that she wouldn't have, beyond what she presented at the contempt hearing.
And so I think, though, that we have presented the court with a transcript and identified the exact dialogue between the trial court and trial counsel for my client, where there was simply not an opportunity to develop all of the witnesses. Even at one point, trial counsel.
Okay, but what witnesses? That's what I'm saying. You keep saying that, but what witnesses? What evidence would you have developed that you didn't have an opportunity to develop? Because even to this point, you keep talking about this due process violation, but what were you actually deprived of presenting? What would you have presented that you did not have an opportunity to present?
Well, the standard for whether or not someone is in contempt of an order is much different than whether or not there's been justification to extend an injunction. I mean, the statute makes it clear that there are 6 factors. I think that whether or not my client intentionally and willfully violated an order, which I think the order on the motion for contempt does not even rise to the level of making those findings. I think that the preparation for the hearing would be much different. The cross-examination of the witnesses, the ability to present more evidence, whether or not, if we're looking at another 2 years versus.
Well, for all practical purposes, the trial judge spent the better part of what I think was at least a day listening to everything that had happened since the injunction was entered through the present, including testimony from uninterested third parties like the retired NYPD cop that lived down the street. And so what would be different? I understand that you're saying there's different burdens and standards, but how much more process would have been due if somebody had filed a pleading with the magic word in it, as opposed to what happened here?
Well, I don't think that it can be considered a magic word. I think that parties are entitled to notice of the relief sought against them. I respectfully think that goes to the heart of our due process argument.
Well, your client starts out knowing that she's on the hook for violating the injunction, right?
And at this point,
and wait, stay with me. And she's at the hearing where the fact-finding process consumes several hours to go through those violations, and the trial court has at least some discretion here. Your client knows that the trial court's trying to fashion a remedy to ensure compliance. And from the trial judge's perspective, it seemed ideally without escalating this to a criminal level. So I don't mean to beat the horse all the way to death, but what exactly, we don't have a proffer. I think that's what my colleague is asking you about. And it's hard to fully appreciate where this would go and how different it would be if we just sent it back for another hearing, because now your client is well and truly on notice that there's likely to be an extension here.
Well, again, Your Honor, I just go back to, I don't think that magic words are there was never even a discussion of modification. If you look at the opening statements that were made, the hearing was narrowed to the limited issue of whether or not my client was in contempt of the first injunction. Trial counsel for appellee even goes so far as to say, we might have to come back and file another order if the court is not inclined to extend the injunction. So I understand that the court is saying that had, the trial court been asked to modify the injunction as a result of the contempt violations.
That wasn't what I was asking. My question was not whether the trial court had been asked. My question was whether the trial court had inherent authority to modify.
I think the trial court does have inherent authority as long as there's a written motion and notice of what the trial court is going to
That's at odds with inherent authority.
But listen, what I'm trying to say, and maybe I'm not answering the court's question correctly, is whether or not something rises to the level of contempt. Respectfully, I think that that's a different standard as to whether there's been notice that the court is going to extend the injunction.
Which standard is higher?
The contempt.
Okay.
But I think, and I think a full look at the record before the court I think that there was not an opportunity, putting that issue aside, there was not an opportunity for, my
And
clients.
your client didn't appeal the contempt.
Well, right now it's non-final, Your Honor. So there's been no amount set. She, fully intends on considering that option if we ever get to that point. So that was noted in the initial brief. So, just respectfully, we're dealing with a 3-page motion outlining that there's been a contempt violation. There was preparations to address the 2 incidents raised in that contempt motion, and the standard for whether or not there was a violation of the underlying first injunction versus whether or not the trial court could modify the injunction. That request wasn't even made by counsel. I mean, he goes out of his way, trial counsel for the appellee goes out of his way to say, typically we need to file a separate motion. I mean, everyone at that hearing was under the, was well advised and well informed that the matter before the court that was noticed was whether or not the Mrs. On had, violated the first order. So, and that's, I think that that's also supported by the fact that there were 2 orders entered. There's one outlining the fact finding that the trial court conducted as to whether or not there was a willful violation of the first injunction. And then it seems at the end that she sua sponte just extended the injunction for an additional 2 years. There was a separate final judgment entered. So we're not dealing with just the same order. There was one order outlining the basis for her findings of contempt. And then there was a second order entered, a second final judgment. So, we're not dealing with a situation where even the trial court is claiming that she's modifying the first injunction as a contempt sanction. She simply entered an order on the contempt charge and then entered a second. I just want to make sure that I'm not misstating something. There was a second final judgment, second injunction entered. So, I maintain that that was not a remedy sought by appellee in the trial court. That did not seem to be the motivating factor behind what the trial court did. She obviously made her findings as to contempt, and I believe she separately entered the second stalking injunction. But if I understand the questions the court are asking, and I think that they're valid. But that certainly brings us to the second point that we've raised on appeal. So, and I'm looking at record 115, 116, Your Honors. That's the order on the motion for contempt. So the court on the contempt motion, which was the subject of the proceedings that day, held my client in indirect civil contempt for the phone call made by her husband to the non-emergency line, imposed sanctions in the form of appellee's trial court costs and attorney's fees, and reserves ruling on the amount of fees to be ordered, and then separately enters an amended final judgment, does not make a finding that she's modifying it. So I understand that while a trial court does have the inherent authority to modify an injunction, I think that's a
Does
separate.
she have to make findings to modify? I mean, it's called amended final judgment.
I'm not saying that she has to, well, I think first of all, that there needs to be findings in the final judgment to have it withstand the scrutiny of this court, who's going to look at the totality of the evidence to see if the injunction itself was warranted. And obviously we're getting a little more into the merits of the case at this point. But, you know, I feel like
What the record establishes is that your client violated the injunction by engaging in substantially the same conduct that gave rise to the injunction in the first place.
well, respectfully, what the record shows is that the sole basis for the finding of contempt was a phone call made by her husband to the non-emergency line of law enforcement. So that was the sole basis for the finding of contempt. And that's the same record site.
Ms. Giassi,
Yes, Your
excuse
Honor.
me, but I just want to remind you, you are now into your rebuttal time.
Okay, I will reserve the rest of the time. Thank you.
Thank you. Mr. Haskins?
May it please the court, Jesse Haskins for appellee Megan Arujo. Ms. On's due process rights were not implicated when the court enforced its prior unchallenged injunction order. And even if Ms. On did have a due process interest in the second order, the only appealed order, she waived them through implied consent. Early on in the hearing leading up to this second order that is now under appeal, counsel for Ms. Arujo stated his intent to seek a second injunction. And he did invite the court and opposing counsel to make some sort of objection and have a subsequent hearing. I think given the disagreement as to what exactly was said, it's worth repeating. And this appears in pages 230 to 231 of the record. We need to get this to stop. And so that's why we're asking that attorneys' fees be paid and that there be essentially a coercive fine. And also, if the court is so inclined, to extend the injunction. If not, we can file a subsequent motion for the injunction. But neither the court nor opposing counsel raised any issues with due process. In fact, given both the nature and the time sensitivity of this, it appeared to be in the interests of all parties to get this resolved sooner rather than later. Ms. On evidently had a hope at the beginning of the hearing that she would be able to have this injunction terminated immediately and reap the benefits from this immediately. The court also noted that it would be on the table to seek, and for the state attorney's office potentially, to seek incarceration. And that, as the appellant recognized, is actually well within the court's enforcement powers under Parisi. Sanctions and contempt enforcement powers as severe as incarceration could be imposed pursuant to the court's general contempt and enforcement powers. So the order being challenged is actually a show of both restraint and moderation from the court and from Ms. Arujo. Ms. Arujo recognized in deeply human terms the bind that Ms. On was in, and she stated she doesn't want incarceration. Her goals of just being left alone would be served just as effectively through an extension of the injunction, through a second injunction. And so that is what the parties agreed to proceed on, is to have this hearing on contempt that would include both attorney fees, which is currently not under appeal, as well as the injunction itself. And this court case also really highlights the importance of allowing the court to exercise its jurisdiction as a fact finder. Because one of the issues under contention factually is what was actually said in 911 calls. Tone of voice, background noise is not picked up in the record. It was also clear from the hearing that one of the first items that Miss On's husband, under the direction of Miss On, said is, my wife, she does have a restraining order against her. There's some indications raised in the answer, I'm sorry, in the initial brief and the reply brief about the potential ambiguity of the use of pronouns. But again, the court was in the best position to evaluate, in addition to the express words used, nonverbal signals and tone of voice, which is especially important in this case.
Well, we can listen to the recordings of the 911 calls ourselves, right? We're not bound by the trial court's factual determinations with respect to the phone calls themselves, are we?
I'm not aware of the actual audio recording in the transcript. I saw there's an excerpt.
Was there not an audio recording entered with the dialogue? Maybe I might be recalling it incorrectly. Was it just testimony recounting, or? No, there was a recording.
There was a recording. The recording was presented to the trial court, who also picked up on background noise. And it may be a technical oversight on my part, and I apologize if I'm not fully aware of the record before the panel. But regardless, the trial court, as it was being presented to it, was in the best position to evaluate the credibility of witnesses.
Of the live witnesses, is what you're
Yes,
saying.
and I think at one point in the transcript, the judge said that she had to go to her chambers to actually try to pick up on the background noise as well. So there may be some issues in terms of reproducing the audio to the same fidelity. I haven't frankly heard the audio myself. But I think regardless,
But the bottom line, right? The audio files were played in the trial court and reproduced to whatever the best of the court reporter's capacity was. I mean, there's like a sequential introduction of each of the audio files.
Yes, Your Honor. With respect to inherent authority, because there was already an injunction ordered, there were no new rights being adjudicated. That was the holding of the Florida Supreme Court in Jackson Grain Company. And that idea of injunctive orders not actually creating new rights and therefore not carrying the same due process interest was applied specifically in the context of injunctions against stalking, much like the case here. And that case was Miguez versus Miguez. There are a number of examples of courts exercising their inherent authority to enforce and to hold contempt in terms of granting injunctive relief in solutions that were not pled for, that in some circumstances may not even been able to be fully contemplated. Brill versus Brill, for example, involved a distribution of marital assets. There actually was a motion for contempt order along with motions to enforce. All three were considered on appeal. The motion for contempt was actually affirmed on different grounds, but the motion to enforce, the order on that was requiring the wife to sign a listing agreement on the sale of property. And it doesn't even need to be in the same class of remedy. Brill versus Brill, for example, involved the order granting specific performance on a sale. When the sale did not happen, the court used its general enforcement powers to issue money damages. In terms of whether the due process rights, if she has them, can be waived, the idea that they're non-waivable is refuted by Ms. On's own cases, specifically in McElroy versus Oaks on the Bay. This court quoted the Florida Supreme Court in stating, "A party may waive a legal right, whether secured by contract, conferred by statute, or guaranteed by the Constitution. A party waives such right by taking action that is inconsistent with that right." And in the Smith case, the essence when we're talking about implied consent is whether there's actually prejudice. And I think it's clear in this case that there isn't. An appellant hasn't been able to identify any particular witnesses or evidence. And there are two interrelated criteria, I think, that really distinguish appellants' cases from what's happening, especially the latter criteria of whether opposing party could have offered additional evidence. There are cases where there actual are different sets of core facts, where unpled theories implicate different and require gathering and discovery of additional evidence. The Druin case, for example, involved a foreclosure. The homeowner pled an affirmative defense. The bank did not plead an avoidance, but tried to argue that by the homeowners presenting testimony on their affirmative defense, the bank's avoidance was tried by implied consent. The problem with that was the court actually found that the homeowner's evidence was, quote, not related to the bank's avoidance, and therefore there was no implied consent. This case is more on the footing of Hemraj versus Hemraj, which was adopted by this court in Hess versus Hess. Hemraj, like this case, involves unpled relief. Specifically, Hemraj was a dissolution of marriage case. The wife did not plead alimony, but she raised alimony in her pretrial statement, in her opening statement, in her closing statement. And the husband actually did say that he was opposed to the award of alimony. And he explained why. He, I believe, said something along the lines of improper conduct. Just because the husband engaged and opposed the particular relief being sought did not mean that he withheld implied consent. The court still found implied consent. So on this issue of whether a party can just raise a general objection and call due process later on an appeal or on a second motion for rehearing when they're not happy for result, I think Hemraj indicates that an appellant can't do that. There needs to be a particular objection to put the court on notice of what is being overlooked. The appellant's objections here are similar to the husband's objections in Hemraj. There was, I think, a vague objection. It's too long, and I think Ms. On also argued, tried to point to some type of testimony favoring her position. But that's the same level of vague reservations that was at issue in Hemraj versus Hemraj. And for these reasons, unless there are further questions, I would urge that the decision be affirmed.
Okay, thank you, Mr. Haskins. Ms. Giassi, rebuttal?
Yes, Your Honor, briefly. I just want to start out, so there was never an argument in the answer brief, Tipsy Coachman or otherwise, saying that this form or substantive reform, that this was modification within the courts or the trial court's ability. So my response to that is, while yes, the appellee could have raised those issues, this court cannot affirm Tipsy Coachman on a basis unless the record before it supports that. And so when you look at the two orders entered by the trial court, one finding contempt with the first injunction and the second injunction, there's no findings that there was a significant change in circumstances. So I frankly would submit that the court can't consider that. The court cannot affirm on the basis that it considers this second injunction a modification of the first. The trial court simply didn't make those findings. That was not an argument advanced in the trial court. It certainly was not an argument advanced by the appellee in its answer brief, because that would have been the response in the reply brief, is there are no findings that could justify a modification of the injunction. Now, if the court had made those findings, and maybe we'd be in a separate position, but those weren't made. So that's not a basis on which this court can affirm. Second, we have gone through and cited this court with an extensive amount of case law dealing with circumstances such as these, where we're dealing with injunctions or child custody matters. And the fact of the matter is, even if I think starting even with the Mazzari case cited by my opponent, and he tried to compare that to the Fourth District case of Brill. Brill involved post-judgment collection proceedings. I'm sorry, not Mazzari, Miguez. And we've outlined, and I don't need to repeat it for the court because it's in the brief, but that case directly supports the reversal of the final or the second injunction in this case. It involved the court in Miguez extended a domestic violence injunction after there was finding that the father's due process rights were violated because the trial court just sua sponte modified the original injunction. So that was a due process violation. And I think there are so many cases cited in both the initial brief and the reply brief that deal with a hearing that starts out as one on contempt, which results in additional relief that was not requested by the parties, just like here, where we started out with whether or not Mrs. On was in contempt of the first injunction, and we ended up with a second injunction that certainly is facially insufficient, doesn't contain the findings necessary for entry of the injunction, and it certainly doesn't make any findings that there was a significant change in facts and circumstances that would give the court the inherent authority to modify the injunction. So I would respectfully, just on that specific issue, again, that wasn't raised or argued in the briefs, that this court cannot affirm on that basis, finding that the trial court simply utilized her authority to modify the injunction. The second point that I just wanted to mention briefly is I know that there was a significant amount of the briefing devoted to whether or not this issue was tried by consent. I find that unavailing. I don't think the record supports that. All of the evidence discussed during the contempt hearing related to whether or not my client was in contempt. I think the record is replete with objections when you look at the opening statement provided by counsel, who not once, not twice, and then I think even his client is asked on the stand, and I'm referring to trial counsel for appellee, so Ms. Orejo, she's asked, does she intend on filing a motion asking for the injunction to be extended? And she unequivocally says yes. And then, just to distinguish, I think, some of the confusion of my opponent dealing with procedural due process on, maybe the admission of evidence or whether or not, something like that amounts to, the denial of due process that, we're seeing in this case. I just think those are easily distinguishable. That's not what happened here. During the hearing, it was, framed by counsel for Ms. Arejo that they were here seeking contempt. And if they needed to file, they intended on filing a motion. Even the judge, I believe, at some point says, typically that's done a month before the injunction expires. As the record reflects, we were still 6 months out. And just to briefly address the motion for rehearing issue, even though counsel objected, didn't say due process, but when the court brought up at the end of the hearing that she was considering extending the injunction, again, not modifying the injunction, he specifically asked for an evidentiary hearing. There were two.
Ms. Giassi, excuse me, but you're going to have to wrap it up.
Okay,
please.
very quickly, Your Honor. My client wants her day in court. I think she's entitled to her day in court. Injunctions, as this court have recognized, have serious and long-lasting consequences. And, she should be able to review whatever petition the appellee files. She should be able to adequately prepare for the hearing and present the witnesses that she deems necessary to rebut the allegations in a still yet unfiled petition. And so on that ground, we're asking the court to reverse and remand. And, I'll just end because we've had a very collegial and entertaining discussion about due process. I would just urge the court to look at the final judgment. Facially, it's invalid. It doesn't make the findings necessary to warrant an injunction under the stalking statute. And it certainly doesn't make the findings that would suggest the court modified the original injunction as a contempt sanction or under its inherent authority. And I thank the panel for its time and its consideration.
Very good.